Початок
Good
трансляції.
afternoon. Good afternoon, dear colleagues, the public and the candidates. The advisory group of experts gathered in the full composition to conduct an interview with the candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Smokovych Mykhailo Ivanovich. He was admitted to competitive selection by the decision of the Council of Judges of Ukraine. Mr. Smokovych is a judge of the Administrative Cassation Court of the Supreme Court, and he's a head of this court. We are ready to start, and I will give the floor to the Secretary of the Advisory Group of Experts, Mr. Romaniuk, to explain the algorithm of our work today and to moderate the interview. Please, Mr. Secretary.
Thank you, Mr. Chairman. Hello, Mr. Mykhailo. Hello, everyone who is watching our broadcast now. As the chairman has mentioned today, all 6 members of the AGE are present at the interview. Some of them are present in person here in this room. Some of them take part in the meeting through the video conference mode. In particular, the AGE meeting is attended by the chairman of the AGE, Mr. Aleš Zalar, members of the AGE, Ms. Hanna Sukhotska, Ms. Maureen O'Connor, Ms. Oksana Vasilchenko, and Mr. Vasil Shakun, and I, Secretary of the AGE, Yaroslav Romaniuk. Also in this room we have deputy members of the AGE present. We have 5 of them. That is Mr. Thomas Griffith, Mr. Richard Barrett, Mr. Marek Zubik, Mr. Volodymyr Kuzmenko, and Mr. Vitaly Hinchuk. Now I will briefly explain the regulatory framework and the procedure for conduct of the interview. The interview is one of the mandatory stages of evaluating the criterion of high moral qualities of candidates for the position of the judge of the Constitutional Court of Ukraine. Actually, the interview allows you, as the candidate for the position of the judge of the Constitutional Court of Ukraine, to refute any possible doubts that have emerged among the AGE members with respect to your compliance with those high moral standards that are required for the position of the judge of the Constitutional Court of Ukraine. The AGE kept in touch with you, and we are grateful for providing answers to those questions that we are interested in. We've analyzed them carefully. At the same time, there is a need to have this in-person meeting, interview, in order to clarify some questions and to get some answers from you in person. In connection with this, I would like to also to explain to you that today you cannot provide information, documents, or other materials which we asked you to provide previously, but you did not do that, or that you would like to provide upon your own initiative today, even though we did not know about them before that. At the same time, we may make an exception to this general rule if we decide that there are justification for that. I would also like to inform you that our interview is being recorded and broadcast live on the resources of the AGE and at the website of the Constitutional Court of Ukraine. In connection with this, I would also like to draw attention of members of the AGE with respect to the restriction of the use of the sensitive data and information with limited access during the live broadcast. If it is necessary to voice this information, we will suspend the live broadcast so that the information with restricted access is not disclosed outside of these premises. I would like to inform you that we intend to plan to conduct the interview with you within 1 hour. So I would like you to answer the questions that you will receive from us concisely, briefly, trying to answer them within 3 minutes with respect to each question. After the interview, you will have the opportunity to address the AGE with a closing statement that should last up to 5 minutes. Is everything clear to you? Mr. Mikhailo? Yes, thank you. Everything is clear. And now we are ready to move on to the interview itself. And the co-rapporteurs with respect to you are members of the AGE, Ms. Maureen O'Connor, and I, Yaroslav Romaniuk. And the interview will be started by Ms. O'Connor. Please, Ms. O'Connor.
Thank you. Thank you. Good afternoon. I have a series of questions to ask you about your property ownership, the apartments that are associated with you. So we'll start there. In 2002, you and your family moved into government-owned apartments. I believe it was a 4-room apartment in Lusk. To which category of citizens did you belong in order to obtain the right to reside in that apartment? Was that due to the fact you were a judge?
It was more related to the fact that I was affected by the accident at Chernobyl nuclear power station. And then additionally, I was also a judge because I was registered as an IDP from the area of Chernobyl zone. And I used to live on the territory during the accident at Chernobyl power station, which was affected.
Thank you. In January, or from January to May of 2004, you changed your registered place of residence within Lutz, but you continued to actually live in the same apartment. Now, during this same period, in March of 2004, your mother and 2 of your children privatized this apartment. In your written responses, you stated that you changed your registration due to the privatization of the apartment. Is that accurate?
Yes, yes.
Why did you not want to participate in the privatization of the apartment in Lutz and deregister your residence from there?
Once we applied for the registration, we had 4 persons as family members who had residential checks, so-called. And our residential checks were counted for privatization of 94 square meters. The apartment had the area of 77 square meters. So that is why our residential check exceeded the area of the apartment. And upon notification of the privatization department, our residential checks had to be divided into parts. And after privatization, each of us, that is I, my children, and my mom, had the right to privatize of state-owned housing in another apartment for the remaining area. And so in order for my children to use their checks completely, it was I suggested and my wife suggested, the privatization department advised as one of the solutions to have me deregistered from the apartment so that I would not take part in privatization process of this apartment. The residential checks of mother and children were enough almost for entire apartment. Only 3 square meters only for 3 square meters we had to pay additionally. So that is why with the right for further privatization of residential area, only I had this right. If I didn't do that, then all of us had some shares of this right. And the law set out back then, when we are talking about the law on privatization of a housing area. So these checks could also be used for acquisition of land plots. And our family intended to acquire land plots close to Lutsk for a house. Back then, no one even thought about Kiev.
In December of 2003, the Verkhovna Rada of Ukraine appointed you to the position of judge of the Higher Administrative Court of Ukraine. So by December of 2003, you knew that you would soon be moving to Kyiv. Did you refrain from privatizing the apartment in Lutz because you understood that as a judge, so you could obtain and later privatize an apartment in Kyiv. Was that part of your consideration?
This was not a part of my considerations, because if that were a part of my considerations, then my family would have moved completely to Kiev, and all four family members, including I, my mom, and my children, would have had the right to privatize the state-owned housing in another apartment. So, no, there was no need in that. And with respect to this, there is a decision of the Constitutional Court of Ukraine, dated 2010, I think, October 6, where the Constitutional Court explained that the use of the residential check and additional area in addition to the residential check and its complete use can be used during privatization of several apartments. So there were no considerations about the privatization back then. And even if I had, then I think it would have been better to be able to privatize apartments both by my children, me, and my mother.
In May of 2007, you're allocated an apartment which was owned by the Higher Administrative Court of Ukraine. Among the family members, apart from your wife and two children, you also listed your mother. And you received a 4-room apartment with a total area of 143.3 square meters. And it was 87 square meters of living space. The Higher Administrative Court of Ukraine received 12 apartments in this building, but yours was the largest. And how did that come about? On what basis did you acquire the largest apartment in the building?
I was selected as the judge of the High Administrative Court on December 11 of 2003. The legal entity, High Administrative Court, was registered on January 5 of 2005. So until then, we were looking for the premises of the court, etc. We were organizing the work, and we were registering the court as the legal entity. Then there was the Code of Administrative Judiciary Proceedings adopted, which was vetoed by the President, and only on July 6 of 2005, the Verkhovna Rada of Ukraine overcame the veto, and the Code of Administrative Judiciary Proceedings was adopted. And then, since the 1st of September of 2005, we were supposed to start working. When we started working, there were 18 judges in early September of 2005, including 11 judges who were candidates for the receipt of housing. In connection with this, we started the market in Kyiv, and a budget application was made to the budget committee of the parliament, and according to which the parliament adopted the law on the state budget for 2006, and Annex number 3 set out that for purchase and construction of housing for judges of the High Administrative Court of Ukraine, there had to be allocated 10,980 hryvnias. That is according to Annex number 3 to the law on the budget code. And so for 11 judges, I had more than 1 million as allocated for me. We were supposed to construct the building close to the Central Election Commission in the Kyiv center, but once it came to the implementation of the law on the budget law, then we had 28 judges in the court, and other judges required housing as well. So it was decided that to find some cheaper housing, and we found it in this particular building where my apartment is located. Not in Pechersk district of Kyiv, but in Holosivsky district of Kyiv. The area, the price of the square meter was much cheaper in that building, and with respect to this, But this was a building close to the road, close to the railway, close to two factories, including Sweets and Allcom factory. It was not far from the bus station, and there were airlines over the building.
Зараз.
All right.
Кажу.
What?
Going to be pressed for time because we have a lot of questions to ask you. And I'm going to ask you to be
Добре.
more concise and more direct in your
Добре.
response. So
Добре,
how did you happen to get the largest apartment?
The housing committee of the High Administrative Court that was formed studied all of these issues, and according Article 44 of the Law of Ukraine on the status of judges, which was valid back then, judges had the right for the housing with additional area. The housing committee gave additional area to each family in the form of their room. And my children are also of different sexes, and they require separate rooms. So we required 4 rooms, and in connection with the fact that these rooms were a bit large, we have this residential area. And also, my mother was supposed to live with us, but the chair of the housing commission said that she could live together with a granddaughter, so that's why we got 4-room apartment. That was in line with the housing legislation and with the laws which were valid back then, in particular the law on the status of judges, and in particular Article 44. With respect to the apartment that was at the balance sheet of the High Administrative Court, unfortunately, I could not find documents with respect to this. But according to information from officials, these apartments were out of the balance sheet budget of the High Administrative Court. They were never on the balance sheet of the court.
And so one of the reasons you had a larger apartment was because your mother was living with you. Is that correct?
No.
Was included in your family grouping did not entitle you to a larger apartment.
My children, myself, and my spouse, according to legislation, we had to have 4-room apartment. About the size, also, my mother was taken into account. You must understand, 4 rooms and size are different things.
You're saying that there was no increase in the size of your apartment due to the fact that your mother was part of the list of people that were going to live there.
Maybe the housing committee took this into account, but the planning of the building was such that 4-room apartment I would be provided even without my mother. The rooms were quite big, but mother definitely was taken into account when the housing was provided to me.
Your mother didn't end up living with you in that apartment. Is that correct? She actually, based on the information that we were able to discover, she lived in the apartment in Kyiv for about 2 months between the periods of 2007 and 2010. And in fact, she was receiving her pension paid to the post office in a totally different district. That's accurate, correct?
My mother lived in this apartment about 4 months. That was beginning of 2009, from Christmas and the Easter. She came back to Lutsk. My mother, all her life, since 50, she was 50, was receiving her pension in the village, Veliki Kurin, in Volyn Oblast, and she has always been registered there as a pensioner, and she received her pension delivered to her by a postman.
That region
Okay,
to
okay.
get her check or her pension, correct?
It's a village, and her pension was received by our cousin. It's a village. The post woman is the neighbor, and her cousin lived near the post office, and so my mother's pension was received by her cousin. But we arrived there and took it from him.
You in the apartment uh, all the time? I thought you said she was only there for a few months.
Ні. Мама проживала ще.
No, my mother lived from January, beginning of January, 6th or 7th January 2009, until Easter holidays. And
Correct?
Так.
yes,
Так.
Okay.
yes.
In this apartment, where was she living?
Вона жила.
I received an apartment in March 2007. I received permission, and the family was registered in May 2007. Those who received the state apartment, they understand me. So when I opened the door of my apartment, there was nothing, no internal works done in this apartment. So I managed to complete the refurbishment in a year and a half. So I was not able to bring my family to the apartment at the very beginning because it was impossible to live there. Only in May 2008, my son had to go to school. I brought him in September for him to start going to school.
This is for the apartment in Kiev?
В Києві.
All right. So where did you live while you were refurbishing that apartment? Where were you, your wife, your children, and your mother?
Моя дружина.
My wife and my children and my mother lived in Lutsk, in the city of Lutsk. My wife worked at Volyn Oblast Procuracy. My son studied at school, and they also were taking care of my mother, as well as my wife's mother helped them.
During this time, 2007 to 2010?
Мої батьки були.
My parents were married all the time. My father died in 2010 on the 13th of June.
In 2007, 8, 9, until he passed away in 10?
Частково разом, але в мами.
In parts together, but my mother had problems with her spinal cord, so she lived mainly in Lutsk in the apartment, together with my wife, who was taking care of her, looking after her.
Батько жив.
My father lived in the village because at that time they had some he had a horse, and he had to take care of that horse. He had some vegetable garden and so on. Uh, with-
Okay, in 2010, your mother changed her registration to the Volyn region. In your opinion, could an observer, an outside observer, get the impression that your mother was listed as a family member merely for you and your wife and children to obtain an apartment, a larger apartment than you would have been able to have otherwise?
Всі, хто знає мою сім'ю,
all those who know my family and composition of my family wouldn't think like this, and I think that outside observer would not think like this, because everyone in the village and know what was my attitude to my mother, how I was taking care of her. Maybe he would continue living with me, but according to our traditions, the youngest son should take care of parents, but her junior sister agreed to take care of her. She moved from Kiev because she couldn't live in Kiev. She didn't hated the railway sounds of the railway which was nearby, as well as aircraft flying over the building to Julane Airport.
You just mentioned, you know, people who know you, people from the village, etc., wouldn't think that, but you know, this process is being viewed by many more people than just the people in your village. This is the people of Ukraine are able to view this this interview. You and your family members received 3 apartments from the state, 2 in Lutsk and 1 in Kyiv. Is that accurate?
Так.
Yes.
It appears that you plan to live with your mother in Kyiv, but you're saying that didn't work out. She didn't like Kyiv for all the reasons that you mentioned. So then your mother invested in the construction of an apartment in Lutsk in the beginning of 2006. Is that also accurate?
Ні, не так.
No, not. In 2006, I didn't invest anything in Lutsk.
Ні.
No.
У моєї матері
My mother has 5 children. 3 sons, I'm the youngest, and 2 daughters. And our senior brother, he has been living in Russia, and after retirement he planned to move to Lutsk with his wife, so that was his investment. And so
Investment. Okay. All right. I'm going to ask that we
Це
now.
інвестиції його.
that was his investment, yes.
I'm going to ask now that we turn the camera off at first.
Я
The
попрошу зараз,
next series
я
of
попрошу зараз обмежити
questions.
трансляцію. Для наступних запитань обмежити трансляцію, щоб інформація, яка буде лунати, не була
Limit the information not to distribute
Okay. I'm going to ask you questions now regarding the certification of prosecutors in the cases that you heard related to that. Your wife previously worked in the prosecutor's office, and I believe it was in excess of 10 years. In 2019, there was a reform, large-scale reform, I'm sure we're all aware of, that aimed at purging the prosecutor's office through a certification of the prosecutors in Ukraine. And that time, your wife was supposed to undergo certification, but ultimately refused, and as a result of that, left her position. She was dismissed from the prosecutor's office. So, in other words, if not for the certification, your wife could have continued working at the prosecutor's office and maybe advancing her career there. Is that correct?
Це все залежало від дружини, якби вона захотіла.
That depended on my wife. If she wanted, I wouldn't agree. Why not?
She would have still been there but for the certification process. Okay. After your wife was dismissed from the prosecutor's office, you reviewed several cases, well, more than several cases, in which prosecutors challenged the results of their certification. Right? And my understanding is that some of those prosecutors that challenged, and some of the cases that you heard, involved prosecutors from Kyiv, which is where your wife was employed. Okay? Why didn't you recuse yourself from the cases of those prosecutors who were colleagues of your wife?
Чи не вбачаєте ви конфлікту інтересів в цьому? Чому ви не заявляли?
Don't you think there was a conflict of interest? Why didn't you declare self-refusal?
Що коли я став суддею,
I will say that when I became a judge for 28 years, together with my wife, she is a prosecutor, I'm as a judge, worked in parallel in our own spheres, and I've never thought that there would be certain grounds for self-refusal. And in this situation, my wife submitted refusal to participate in certification. So we have never discussed whether it's legal or illegal. If we had such cases, then the judicial practice showed that the dismissal was done correctly. In my situations where there were different reasons to revise the results of the certification, and the case which was mentioned in the request was about absolutely different thing. It was not about passing the certificate, it was about not passing the certification. And the decision was taken that the personnel committee didn't take into account all circumstances when voting. 3 members were for, 3 were against. That's why our courts cancelled those decisions and obliged the personnel committee to take all the circumstances into account. All that had nothing to do with dismissal of my wife. My wife didn't stand for her rights in the court and didn't appeal that decision, so I didn't see any reasons for self-refusal.
We analyzed the court decisions that you made regarding the prosecutors who were appealing their decision, and out of, we looked at 15 decisions in favor of the prosecutors. In other words, you ruled with the prosecutors. And 9 of those prosecutors were from Kyiv, which was the area, you know, your wife had been employed more than 10 years from the general prosecutor's office. And as I said, she had worked there, undoubtedly knowing the people that were the subject of these cases that you were hearing. So, and then out of 39 decisions in favor of the office of the prosecutor general, only 3 concerned prosecutors from Kyiv. So, in other words, the cases that came out of Kyiv and the prosecutors that objected to the decision, for the most part, it looks like the system, the majority of the positive decisions are in favor of Kyiv prosecutors, again, where your wife was formerly employed, while most of the negative decisions concern prosecutors from other regions. Now, if an average citizen was looking at that, knowing that your wife had worked there for 10 years in the prosecutor's office, and that colleagues, people that were in that same office, had a positive result when they appealed their certification denial, and that you were the judge, involved in that, would they be justified in wondering about a conflict of interest?
З цього приводу
With respect to this, I would like to say that those people, those employees of the prosecutor's office who worked with my wife, were not featured in the cases where I was hearing the cases. There were no claimants. Secondly,
For clarification, none of the people that worked with your wife in the Kyiv prosecutor's office, the general prosecutor's office, appealed the decision. Is that what you're saying?
who were directly working with her. Maybe some of them challenged, but I was not the judge under their cases. I was not the judge hearing their cases. There were other judges under their cases. With respect to the external observer,
Stop you right there. How would you know that the prosecutors that you were hearing the case of, the appeal, how would you know whether they worked with your wife or not? They were all in the same office. How would you know what their relationship was with your wife?
only from claims where they specified clearly in which units and departments of the prosecutor's office they worked. And there were no people from the department where my wife was working. Never.
So an observer, an outside observer, again, knowing that it was one office, knowing that your wife had worked there for 10 years, and that colleagues from that office had appealed and you heard their cases, what do you think a conclusion would be on their part with regards to the propriety of you hearing those cases?
I think that the external observer in this case would follow the position of the General Prosecutor's Office of Ukraine, which was the respondent under the case and which had the right to request recusal of the judge, and there were no requests to recuse me. They knew that I was the husband of the former prosecutor. So that's why the external observers should have no doubts about my consideration of these cases.
So let me also ask you, so your wife worked there for 10 years. Did she always work in the same department within the prosecutor's office?
My wife, when she started working, she started working with not in the organizational department. She started working in the unit on civil proceedings, but she worked there for several months only. If I remember correctly, she worked there in that unit for several months, but during her entire life, during her prosecutorial career, she specialized in criminal proceedings. And upon the first opportunity, she was transferred from the civil proceedings department to the organizational methodological department that was in the department of criminal proceedings.
And so she always worked in the same unit in the criminal proceedings, then presumably for over 9 years.
In structural units of the criminal department, I can't name the specific name, but it was all related to the provision of methodological support to state prosecutors on criminal cases, as well as support in organization of their work. So everything was connected to criminal proceedings.
But it sounds like she moved around and worked with a variety of different colleagues and prosecutors within her 10 years there.
Only when she was employed, when she was transferred from Volyn prosecutor's office to the general prosecutor's office for several months, she worked with prosecutors who were working with civil proceedings. And upon the first opportunity, she was transferred to this another structural unit. Maybe they changed because there was some internal reorganization in the prosecutor general's office, but all of this was related to criminal law, to criminal cases.
I understand that it was all criminal law, but my point is some of the folks from her office, from Kyiv, that appealed it could have, maybe not at the time they received their lack of certification, but previously they could have worked and been a colleague of your wife's over the past 10 years at some point. You're not saying that she didn't know these people.
During consideration of cases, during the study of claims, etc., I did not see such colleagues in my cases where I was the judge.
Couldn't say that she didn't work with them 5 years previously.
For confidently, no, I can't say that.
All right. Thank you.
Let me ask some questions now. Miss Honor will have some rest for now. We do not have that much time left, so I will try to phrase my questions in a more concise way, and I will ask you to provide very concise answers as well. In late 2017, the Supreme Court started working, and the structure of the Supreme Court is that we have 4 cassation courts, including Cassation Administrative Court, which you were heading back then and are still heading now, and the Grand Chamber. Judges of the Grand Chamber, there are 21 judges, and each Cassation Administrative Court delegates 5 judges and President of the Supreme Court. In 2017, your court delegated Prokopenko to this Grand Chamber. According to the law, he could hold this position for 2 terms, that is for 6 years. 6 years passed, and in late 2023 his authorities expired. He started working in the Cassation Administrative Court, and there was a vacant position in the Grand Chamber, and your court had to delegate another judge to this position. On December 11 of 2023, in the Cassation Administrative Court, there was held a meeting of judges, but the issue on appointment of the judge of the Grand Chamber was not included into the agenda. Even though some of the judges, as we know, we've looked through the minutes of the meeting, some of the judges raised the question why the agenda did not include this particular issue. You, as the president of this court, were responsible for the preparation of the agenda. Can you please explain why you didn't take measures in order to delegate a judge from the Cassation Administrative Court to the Grand Chamber? I will explain the situation now. Once the agenda of the meeting is formed, I do that together with secretaries of chambers. And with respect to the selection of judge to the Grand Chamber by the Cassation Administrative Court, then some judges were not present at the meeting, and initially they nominated themselves to the Grand Chamber, and there was already also adopted the law, and Krivanda became the judge of the Cassation Administrative Court, and he was also nominating himself as a candidate to the Grand Chamber. And in order to ensure the equal conditions for all the candidates, so that all of them could run in the elections for this position in the Grand Chamber, this issue was postponed until January 8th of 2024. At the same time, I started the work of the Grand Chamber, where since January 25, everyone was going on leave, and cases were not allocated. So the Grand Chamber was not affected. No, it was not working. It was not considering cases, etc. Okay, back then you gave an interview to one of the journalists, and in one of the things you said that we did not delegate anyone at this meeting, and in the future we will delegate Judge Krivanda to the Grand Chamber. How could you know it in advance when the decision is taken by the meeting of the judges and not by you personally? After one of the interviews, I'm not given any more interviews, you know. I did not give that interview. Why did you voice the surname of Judge Krivanda in advance before the decision of the meeting of judges? I did not give interview to any journalists, and I did not give this interview, and I was not saying that. We were talking in the staff that Krivanda will take part in the election. And the meeting of the judges was properly organized. There was secret voting. Everyone had a chance to run in the election, and Krivanda was chosen through secret voting. Okay. On January 8th, at the meeting, you suggested Oleg Krivanda as the candidate to the Grand Chamber, and you encouraged your colleagues to support this candidacy. Why? Because just like anyone else, I'm a judge, and I have the right for that. Besides, I, as the president, am responsible for organization of the work of court, for consideration of cases on time, etc. And once and Prokopenko's tenure expired on December 7 of 20, and half a year in advance I was thinking how to resolve the situation, because judges were retiring, re-elected, their cases were redistributed several times, and all of this resulted in the situation that cases were not considered on time. So for me, this candidate was beneficial in this respect as for the president of the court. If judges selected anyone else, then we had to redistribute cases of this sitting judge, etc. And again, then we have the issue with the terms, etc. So that was the main reason for me as the president of the court. But with respect to the judge, I knew Krivanda back from the Supreme Court of Ukraine. He is a very responsible judge, and he is demonstrating that. Do you have any personal relationships? No, I do not have any personal relationship with Oleg Krivanda, just like with anyone else. Don't you think that from the perspective of a reasonable observer, this interview to the journalist and then your statement at the meeting of judges can create the opinion that there's some nepotism, that maybe you had some other considerations to support Krivanda as the candidate to the Grand Chamber, but not because you did not want to redistribute cases and that the participants of the court cases would be harmed? I think that the outside observer who knows about the work of the Cassation Administrative Court, who knows about the work of the president of this court, right now the court has received 40,000 of cassation cases this year, and once we try to redistribute cases among judges, then people would not say that. But I did not tell any journalist this. Okay, I understand your answer. Okay, Mykhailo, my next question is the following. Do you know Alla Basalayeva? Yes, I know her. Is it accurate information that we have that back in the past you were the academic supervisor of Alla Basalayeva? Yes, this information is accurate. When did she defend her dissertation? She defended it in 2021. Right now, Alla Basalayeva is the head of the State Audit Service. The AGE has established that you, as the judge, have repeatedly participated in consideration of cases where the party to the case was the State Audit Service. Don't you think that from the perspective from a reasonable external observer, there might be an impression about the lack of objectivity, possible lack of objectivity during consideration of this category of cases? Because your postgraduate student is the head of the party to the case. You did not recuse yourself. Why? I will explain that not I considered not several cases, but dozens of cases. I think about 50 cases where the State Audit Service is the respondent. And the external observer should be competent and should study my relationships with Alla Basalayeva completely. And when I became her academic supervisor, she asked for that. She was the member of the Central Election Commission. Before the defense, and the external observer should know that 13 members of the Central Election Commission were dismissed from their positions because the decision of the Cassation Court, which I'm heading, adopted about 20 decisions which quashed decisions of the Central Election Commissions. Okay, but Mykhailo, we are not talking about the Election Commission. I'm coming to the idea that I do not have any private interests or private relationships with her. That's why I do not have the conflict of interest to recuse myself from these cases. Okay, your answer is clear. Ms. O'Connor has some other questions which concern declarations for 2017. Ms. O'Connor, please.
We're going to talk about the matter of your declarations. And from what year have you been submitting declarations? When did you first do it on paper and then switch over to electronic submissions? What was your first year?
The paper declaration was submitted for the first time. I may be mistaken, but I think it was 2002. But I may be mistaken.
Right, so roughly over 20 years would be a fair statement that you've been required to make declarations of your assets, correct?
Yes.
And you've regularly attended training at the National School for Judges on anti-corruption legislation, including how to fill out your declarations. So any change in the procedure or what those declarations should contain, you've been apprised of, learned about, prior to having to make the declarations, correct? Yes?
Так.
Yes. And і ви протягом довгого часу були декларантом як особа, яка займає особливо відповідальну посаду. На вашу думку, обов'язок коректного заповнення декларації. Could you please repeat once again, excuse me?
All right, you've regularly attended all sorts of training sessions at the National School for Judges on anti-corruption legislation, including how to fill out declarations. Every time there would have been a change required, you would have been informed before you filled out your declaration so that you could do it correctly. And as has already been established, you've been doing this for over 20 years, and of course, all would agree that this responsibility for being accurate in the declarations lies strictly with the declarant, which would be you.
Згоден.
Yes, I agree.
In 2019, the National Agency on Corruption conducted an audit of your 2017 declaration. This was not obviously your first electronic declaration, as you started, I believe, in 2015, 2016, and here we are on the third one. And it contained a number of inaccuracies and errors. Specifically, you did not list the co-owners of the apartment in Lutz. You incorrectly reported data about your vehicles, and you failed to disclose 365,000 hryvnia that was in your bank account. And you didn't inform the NACP about these errors once you discovered them. In your opinion, does this characterize you as a conscientious individual?
Electronic declarations we started filling in 2015, 2016, I think. In 2002, the declarations were very simple on paper, nothing special. But after the law on corruption prevention was adopted, so in declarations on paper were quite big, with a lot of information required. But about these items in the electronic form, they are absolutely new, especially where it concerns finance. I can tell you that that was the interpretation by law about vehicles. It was indicated not the identification number, but the state license number, but now it had to be indicated the number, body number of the car. Identification number on motorcycles still not known, though it is indicated in numbers. Speaking about housing as an object, it's indicated, but we thought that if I am a co-owner, then all the co-owners should be indicated, but I was not a co-owner of this object, but it's shown, it's not hidden. About monetary funds, they're shown because when at the studies, the question was asked to the representative of the anti-corruption agency how to show the costs on the bank card account, and he said that you may indicate it in the line of cash. That was done. So speaking about vehicles, transportation vehicles in Ukraine, it was customary that not the identification number, but number of the body was indicated. About motorcycle, it was a number of the engine and the framework. Yes, that was incorrect. I had to be more attentive, but further on, there were no such mistakes, and I did everything in a proper way. Such details when we studied at the National School of Judges and at other trainings, we didn't study such details. When they start filling in the declaration, then you get many questions. This is my answer.
But you admitted that when I started questioning on this asset, declaration issue, that you've been trained on this, and then you were trained the paper method, and then when it switched over to electronic, or any time a rule changed, you were given instruction as a judge through the National School of Judges about your duty on this. Is that a fair statement?
Ні, такої, я розумію, так.
Yes, I understand. We were not taught how to fill in the declaration. We just studied legislation, how to understand, how to interpret it. But before filling the declaration in, as a chair of the court, I got together all the judges, all the staff, invited the representative of National Agency for Corruption Prevention, and we had additional training. So in details we studied those issues, but that was such an advice concerning the funds, and appeared to be mistaken advice. About vehicles, I recognize, yes, the identification number was indicated, but I thought that had to be a registration number, license number, not the number of the body of the car.
you didn't do it correctly, and your explanation was, I didn't understand exactly. I didn't understand all of the details that were required. Is that a fair statement?
Що стосується
About vehicles, that was a mistake, and about the other, that was the law said like that. Гроші на банківському рахунку.
Would you repeat that? The bank, misstatement about the 365,000. So what you're telling us, from what I can understand, is that you were given incorrect information or incomplete information then you would lay the blame with maybe the National School for Judges or whoever provided the direction that you say you brought all the judges together and had a information session for them on how to fill these forms out, presumably by someone who was learned in it, and you're saying that that person gave you the wrong information on what to do.
кошти показані. Просто вони показані.
Money is indicated, but it's indicated as cash. The sum is indicated. This is a salary account, which known to everyone. There is no grounds to say that it was hidden, but it's shown in another item, another line of cash as electronic money, as we were explained by our trainers.
What about you didn't list the co-owners? The apartment in Lutz?
Щодо співвласників квартири,
About co-owners of the apartment. So the norm is like this. The property should be indicated, the owner of which is the declarant, members of his family, together with other co-owners. And I thought that because I am not a co-owner of the apartment, so nobody should be indicated. Only those members of family, of my family, and the others should not be indicated. If I were a co-owner of the apartment, I understood that I would have to show all the co-owners, because according to the norm, declarant and members of the family and other co-owners. I'm the first, then members of family, and then other co-owners. But in that apartment, I was not a co-owner, so I showed the members of family. But the object is shown. Only my mother was not shown, and before, in all declarations, this object was also shown present.
Line here that I'm seeing is that you didn't fill out the form correctly. It was caught. You didn't discover it yourself and then say, hey, I need to correct this. It was brought to your attention and, through a formal proceeding, and then you had to deal with it. Is that correct?
Так, поясню.
Yes. When in 2019, before the 1st of April, was filling the declaration in electronic and reached the line property, apartment, and I started filling it in as I did it in 2017. The program didn't allow me to fill in the next line, and I started thinking on what was the problem, and then I asked the national agency for explanation, and they explained me that the program will allow me to fill it in further only after all the co-owners of the property are indicated with the indication of the size which belongs to them. So when filling in the declaration in 2018, I corrected that, but it was prompted by the program, by the software. Why the program agreed with my declaration for 2017, I don't know. Usually program do not agree if there is something wrong.
Based on your filling out of the subsequent program or declaration, that you had filled out the 2017 incorrectly, right? And you did nothing to correct that until it was brought to your attention
Tak.
by the authorities. Okay. All right. That's all.
Михайло Іванович, час відведений для
The time for our interview has been exhausted, but still we have some more questions which we would ask you to give answers to. The following questions. The group of experts established that in June 2023 the State Investigation Bureau started criminal investigation concerning possible illegal registration activities concerning a land plot in the center of Kiev. In one of the documents, in the text of this document, it is indicated that according to operational information, you, following the decision of the ex-chair of Supreme Court Knyazev, offered to develop and to register the illegal registration of this land plot at the Supreme Court with the aim of further submission of this land plot for construction or exchange and construction of housing for the Supreme Court. Explain the situation and your participation in this scheme as it was indicated in the court decision. On this case, I would like to explain that at this land plot there had to be constructed building for the Supreme Economic Court of Ukraine and Supreme Administrative Court. The developer had to be the Supreme Economic Court, and the land was provided to the Supreme Economic Court of Ukraine. Maybe it was 2012 or maybe 2013. On this land plot, they started construction works. Some communications were established. About 60 million hryvnias were invested. But as a consequence of the revolution of dignity, all that stopped, and this object was frozen. This is what I know. After that, this Supreme Court was created, and in 2017 it started its judicial practices, and the issue was raised that as far as in the Supreme Court there are 200 judges, 4 cassation courts, to place them all in one premises. Therefore, the chair of the court initiated the defrosting of this construction and to resume construction following the new design. So the construction of the administrative building of the court or residential housing. No, administrative building of the court, and for each cassation court its own building. But there was no money, and the construction was frozen again, and the Supreme Court spends on maintenance of this frozen construction 8 million annually. But whether this is true that following the order of the ex-chair of the Supreme Court, you uh, asked people to develop and to realize this scheme of registration of the legal registration of this land plot at the Supreme Court. Part of this land plot, following the decision of the government, had to be allocated for construction of the embassy of the Turkish Republic. And in this respect, the memorandum was signed. And when the issue was raised on procedure of land plot allocation to the Turkish Republic embassy, so it appeared that communications which were installed on that land plot were transferred to the Supreme Court, but the right to use was not given to the Supreme Court. The right to use the land plot was given to the Supreme Economic Court of Ukraine Liquidation Committee. So there had to be delegation from Turkish Republic. Then the Ministry of Foreign Affairs raised an issue that if when Turkish representatives would come to Ukraine, we would be able to show them where the land plot was in order to establish the embassy. So because of this, the procedure of given from the Liquidation Commission to the Supreme Court, they have the right to use this land plot, which was done by the officials from the staff of the Supreme Court, relevant heads. Did you control this process? No, not at all. The head of the staff, chief of staff, controls the employees, but organizational issues, finding out why the process was delayed, why the court was operational for almost 7 years, but the land was not yet transferred. That was ordered to me to do, to take control. I had one meeting with representatives of the Cabinet of Ministers, State Property Fund, City Administration, Foreign Ministry, and it became clear that it was necessary simply to re-register right to use the land plot, which was done by the employees according to the legislation. After that, I don't know what was done with those processes.
Has the investigator determined your procedural status in this criminal proceeding? Have you been questioned within the framework of this proceeding? I know about the criminal proceeding, and nowadays I know about this, but no investigators, no investigative bodies have summoned me. I have not been questioned, and I know nothing about this status. In your opinion, Mykhailo, let's imagine the situation. You are the judge of the Constitutional Court of Ukraine, and the fact that you are featured in the criminal proceeding, and the fact that there is the possibility to have some leverage to impose pressure on the judge of the Constitutional Court in such a way, because this judge is featured in the criminal proceeding. So, from the perspective of a reasonable observer, how can this be perceived by the society? I will tell you the following. After each election, with respect to judges of the High Administrative Court, with respect to judges of the Cassation Administrative Court, there were criminal proceedings initiated, and we learned about those proceedings after their closure. And the same is here. Someone finds this favorable, someone has done that, but I'll never be influenced in any way, and you do not know about the stage of this criminal proceeding. I know that this criminal case has been transferred to the National Police to the Chief Department of Kiev, because the investigator of the State Bureau of Investigations have no jurisdiction over these cases. They have lots of other work. So the SBI considers cases with respect to officials who are authorized to fulfill managerial public functions, and the case has been lowered to the National Police, which considers a completely different category of cases, right? Yes, I'm convinced that this is so. But I do not have any documents. I just know that since January of 2024, this criminal case has been with the main department of the National Police of Kiev. Okay, Mr. Mykhailo, some other questions as well. In 2017, there was held the competition to the Supreme Court. You took part in this competition, yes. There were several stages in this competition. The first stage was theoretical knowledge testing, and second stage was practical assignment, and in particular drafting of a court decision. The procedure was that at both stages there was the minimum score that candidates had to get in order to move on to the next stage. Some judges who could not overcome this minimum passing score, who could not get this minimum score, stopped participating in the competition. And once the competition was started, the regulation on the competition set out that in case candidates do not get the minimum passing score pursuant to results of the check of practical skills, then such judge would stop participation in the competition. At the second stage, there were about 382 candidates in the second stage. About 50 of these participants did not receive the minimum passing score, and it has also been established that you did not receive the minimum passing score. But back then, the High Qualification Commission of Judges introduced changes to the regulation on the competition and envisioned that at this stage it was necessary to summarize the score for the first stage and the score for the second stage. And if the total score was over the minimum passing score, then the candidate could continue participation in the competition. So that was the way how you managed to pass this stage and continue competition participation. It is interesting that out of those 50 candidates who could not pass the second stage, did not become winners of the competition. You were the only one of these 50 people who became the winner of this competition. Can you explain how did it happen like that? And in your opinion, won't an external reasonable observer have the impression that these changes to the regulation on the competition during the competition, in the process of the competition, were introduced in your favor so that you could have a chance to continue participation in the competition? Please. With respect to this, I would like to explain the following. All of this was decided by the collective body, which was legal, not 50 but 43 judges. And with respect to this, I would like to say that yes, really. In the evening, it was announced that I failed to pass the second stage or sub-stage, but a day later, I will admit you, when I was in the training gym, it was informed that I passed it, and it was a surprise for me as well. But once I looked through the decision, I realized that the HQCJ, didn't you try to influence this process? No, the HQCJ did that according to the law on the judiciary. I studied it, by the way, together with my wife. We looked through the law on the status of judges, and we realized that the stage means the entire exam, and tests and practical assignments are subcomponents of the stage. And the law states that pursuant to results of the stage exam, and the HQCJ did that as well. There were 43 judges like that, but I was not the only one. I think three. One passed to the criminal court, one passed to the commercial court, and many of them. I'm sorry for this inaccuracy. So I was not the only one who became the winner. So I think that this was decided by the collective legal body. They took this decision. I think that I'm convinced that they did according to the law. According to the law, pursuant to results of two subcomponents of the stage, I got 140 points. It was necessary to get 127. Out of 74, I was on 62nd place, and I continued participation in the competition for the Supreme Court. Okay. I did not talk to anyone about this. I did not even think about this. Okay, so you are stating that the decision of the HQCJ was based on provisions of the law on the status of judges. In connection with this, I have a following question. A year passed, and in your proceeding, where you were the presiding judge, there was considered the case that I'm announcing now, following Holubkov's claim, right? Sorry, which judge? Holubkova. That is the judge of Shevchenkivsky District Court of Zaporizhia, Holubkova Marina Anatolievna. The facts of this case are very similar to your situation, but you, as a presiding judge, adopted the contrary decision, the opposite decision. Actually, this decision coincided with a dissenting opinion of the member of the HQCJ, Boyko, who, during the interview at the HQCJ with you, expressed his dissenting opinion. With respect to this, I would like to explain that since in your requests that you sent to me did not include this question, I cannot recollect this decision or this case at all. So I'm sorry, I can't recollect this. Okay, Mykhailo, and before I allow my colleagues to ask their questions, even though we are over the limit of time allocated for the interview, I would like to ask one more question. Looking through the materials that we've accumulated with respect to you as the candidate, among other materials, I noticed that in 2023 you donated about 2.5 million hryvnias. That's over $60,000. In this respect, I would like to get the following information from you. When the full-scale invasion of the Russian Federation into Ukraine started, the Supreme Court stopped administering justice. The President of the Supreme Court moved to Lviv. Where were you, Mr. Mykhailo? And what were you doing? And what is the role of the Cassation Administrative Court in the support of the armed forces of Ukraine? Of what is the role of the court and what is your personal role? What is this donation about? Where did you donate them to? Maybe that it would be not humble. Please do as it is. But over 3 years of the war, I've donated 7 million. Since April of 2022 until nowadays, out of my bank account, or from the account based on my application from the financial department of the Supreme Court, they have been transferred to the National Bank of Ukraine to the account of the Armed Forces of Ukraine, the amount of 7 million hryvnias. And what about the court that you had? Do you have some work done so that the court is the legal entity, so that judges would support the armed forces of Ukraine? Judges support the armed forces of Ukraine to the extent they can do that. I can donate 60% of my income every month. That's official information. So, after all, the start of the war, Knyazev, the president of the Supreme Court, was in Lviv. Where were you? What were you doing? At the beginning of the war, I was at home. from my windows, I saw rockets over Brovary. At 7 a.m., I was at my workplace. I called the car from Lutsk, and I was at work. I ensured the work of the court. I ensured communication with judges. All of us were working online. We created a group at 8:30 together with secretariat. The head of the apparatus was with me all the time. Several heads of the departments were in the court premises as well. Secretaries of chambers were keeping in touch with all the judges all over Ukraine. So this way we were trying to work. I was all the time at work. For the first time, I left Kiev in August. What was I doing? The court basically continued working. All my general functions, orders, instructions were issued by me. The court worked with respect to consideration of appeals, complaints of citizens, which we were receiving in the electronic format. In March, the court adopted rulings. I personally adopted rulings in March. I was also working in the legal battalion, which included people's deputies, academics. We were developing different kinds of legislations. Was it territorial defense? No, no. Well, among other things, we worked with foreigners. We invited judges from Poland to our meetings because we had to immediately introduce changes to the procedural legislation so that judges could work remotely in online mode. In Poland, during the COVID times, they worked online, but we had the war, and even if people were in Kiev, they needed 4 hours to get to the court building, plus the curfew. So, concisely speaking, you were working on introduction of amendments, on ensuring organization of administration of justice in the war time. Yes, with respect to the armed forces of Ukraine, I will tell you about that after the war. Maybe it's a secret. Maybe I can disclose something, so if you allow, after the war. Okay, dear colleagues, dear members of the AGE, Ms. O'Connor and I, as the co-rapporteurs with respect to Smokovych, have no more questions. Do you? Ms. O'Connor has one more question, please.
I just have one more question. This is all news about your donation to of your your assets to the war effort. But was this only your activity, or was this a collective decision by other judges? Are you the only judge in your court that agreed to do this? Was it even discussed with other judges?
I personally discussed this with other judges from my court, but this was like voluntary decision upon their willingness and desire. And until nowadays, some judges still transfer some donations, some donate smaller amounts. They do that to the extent they can. But I officially, because I also have some unofficial donations, but officially I transfer 60% of my judicial salary to the armed forces of Ukraine.
Could you repeat that last part? My microphone or translation went off.
Можу.
Yes, I can. Judges also transfer some donations, but to different extents. Every judge has own personal circumstances. I transfer this officially. Besides, I do a lot of work unofficially for the armed forces of Ukraine. So that's like that. And right now, the court, within a week, produces 2 masking nets for tanks. But this is done by employees of the Secretariat. And we are pleased that our nets are better than the NATO's nets.
Thank you.
Чи є бажання поставити?
Do any members of the AG have any other questions to Smokovych?
Yes.
Так, будь ласка.
Yes, please. The chairman of the advisory group of experts, please.
First, one remark. Mr. Smokovych, when you talk about this exam and the decision of the High Qualification Commission, I must confront you with the official information. You was the only one who passed and the revised process. So no other candidate passed it. But this is not my question. This is just a fact, statement of fact. I have a question with respect to your answer concerning this candidate, Krivenda. First, you said that you didn't have any interview, but are you aware about media articles on this issue? For example, the Mirror of the Week media published quite extensive article on this issue. Are you aware of this?
Так,
Yes, I'm aware about this article.
Didn't react. You didn't ask the media to change the article or to provide the correct information.
No, I did not respond, and no, I did not ask to change this information, even though the information that I provided the interview to journalists is not accurate.
At the time of the judges meeting on December 11, 2023, the law by which the Krivenda became the judge of the Administrative Court of Cassation had not been signed by the president. So if the president had vetoed the law or delayed signing for a longer time, would you have continued to wait until Krivenda then joined the court?
звісно,
Of course, no, because on January 9 of 2024, judges were coming back from the New Year holidays, and it was necessary to start for the Grand Chamber to work. So the last day for this decision was January 8th. And if the law had not been signed by then, by January 8th, then on January 8th we would have held the election, and if judges elected someone else, then someone else would have been the judge of the Grand Chamber from our court.
But you was favoring Mr. Krivenda because there's clearly indicated in the records of the meeting.
Yes. Yes, once the meeting was held on January 8th, then during my question about suggestions, nominations, I, as the judge, had the right to nominate another candidate, and I nominated Krivenda. And yes.
Consider this combination of the previous meeting in December and then in January as inappropriate intervention by you, because you was obviously favoring just one candidate.
No, I didn't regard it as an interference because the judges to the Grand Chamber are selected by the meeting, by judges. I did everything to organize this meeting and secret ballot, and that was done, and the results of the voting speak for this. There were two candidates, and for one candidate there were 23, for another one 14. One vote was against all, so the election took place properly.
Thank you. I have another question. There was another media report. In 2019, there was a birthday party of former deputy head of the Kiev District Administrative Court, Yevhen Ablov. I guess you know him. And this was a small party, closed party. Why do you think he invited you? Are you friends? or relatives, or do you have any other connection, close connection?
Ми і не друзі, ми
Friends, we are not relatives. I'm the chair of the Cassation Administrative Court, and I always congratulate all the heads of the courts and their deputies in the system of administrative courts with their birthdays. And that day in the morning, I congratulated Yevhen Ablov with his birthday. I also wanted to meet with him because I had some questions concerning administrative affairs, and he said that in the evening we could meet at that party. That's why I went in the evening to that meeting, and I don't have any close or friendly or private relations with Ablov, and have never had them, and I don't have them.
That's completely normal, of course, that you attended a birthday party if you are invited by your colleague. This we could see every day in courthouses around the world. The problem was that this gathering received a very, very high level of the public attention, and there were some doubts about this collegiality, how far this can go, to what extent it could influence the decision-making of judges and courts. So my question is, once the media started to publicize this gathering, why didn't you consider to recuse yourself from a case when an appeal against Mr. Ablov's decision came to your court? How do you actually consider situations and circumstances which might give rise to the doubt as to whether a judge would be impartial in given situation?
добре.
I will answer, but first, 3 judges joined the Supreme Court out of 43, not only myself, official information which you received. I need,
Yes, right?
Ні, що стосується
I understand about self-refusal. I didn't have any private interest in those cases. Ablov himself was not a party. He was a judge on these cases. And it's good that you agree with this. I recently visited Vilnius, went through Poland. I met colleagues in Poland. Chair of the court, Jacek Chlebny, and the judges of the Supreme Administrative Court in Poland. Also met with Lithuanian judges in Vilnius, is Polish, and they were surprised that there are some questions in such situations about outside observer, because in Poland they said that birthday of the judge is information about the birthday of the judge is public, and anyone could congratulate him, and it's not connected with the cases or does not influence the cases or self-refusal to process the case. Yeah, yep.
Situation as the general public could see. And as you probably know, you should know as a candidate, you must take the criteria of how the reasonable outside observer sees certain situation. But let me turn to the another answer you provided us today, and this is about the apartments. Because you didn't answer the question, the main question, and that is, how come that you privatize such a big apartment in Kiev you received 86.99 square meters big apartment. And according to the housing code, your family, so together with your kids and without your mother, because she was obviously not entitled to, you would receive 64.6 square meters. So there is quite a discrepancy, and that's the reason why the AGE wanted to clarify this. How come that you was treated in such favorable way in comparison with other judges? Because there is a standard. Each person is entitled to receive at that time 13.65 square meters, and that's it. And this would never come to the 86 or 87 square meters. So that's the question.
Все тут залежало від планування.
Everything depended on the planning of the apartment. My family needed 4 rooms, and myself, as a judge, according to legislation, claimed 1 separate room as my personal study. And the privatization was done according to the legislation. So if I have a right for my share of privatization in the apartment, and I have a right to buy out another part which is beyond privatization or housing check. But I paid житловому
The square meters your family would be entitled to. So thank you for your answers. I have no further questions.
Якщо інших запитань немає,
If there are no more questions, may I add something? I only want to add with these housing checks that myself, my children, victims of Chernobyl disaster, and according to the relevant law on the status and social protection of victims of Chernobyl disaster, we have a right, guarantees on free provision of housing. We have finished the interview with you, and as we told you at the beginning, you are given the opportunity to make your statement, the final statement to the group of experts, not longer than 5 minutes. Thank you, esteemed members of the advisory group of experts. On the 18th of October 1996, the Constitutional Court of Ukraine started operations, and that day I was appointed a judge. I will tell you that the reform in Ukraine is in progress. I have become the full-fledged lawyer in 1991. And I see the development of legal system in Ukraine and see its faults. And I think the changing of legislation, providing guarantees and rights, didn't lead to anything. But when the reform began in terms of personnel, verifying and vetting people, that there must be professionals and patriots of Ukraine, then there is already certain results, and all this is supported. About myself and my activities, I want to say that for 20 years I've been working at the Cassation Instance Court, the court which as a judge who decided political disputes, the cases which gathered thousands of people around the court, rallying around. I know what is political, I know what is to hold the lines, and what is necessary for the Constitutional Court. The Constitutional Court of Ukraine is a stronghold of our democracy. It's a stronghold of rule of law in our country, and a stronghold of protection of rights and freedoms in Ukraine. So this is a great responsibility to be the judge of the Constitutional Court and I realize what I'm going to. Yes, listening your questions, I understand that I'm not ideal, but since 2017, since December, when I became a judge of the Constitutional Administrative Court and its chair, only myself had 7,898 cases. This is not to speak about the cases where I was member of the college. So I'm ready for this position, and I believe that I will cope with this responsibility. Yes, yes, mass media, the authorities don't like me, and they have never liked me, but I'm proud of this, because if the authorities don't like administrative court, it means that administrative court is on its proper place and protects rights, freedoms, and interests of people in Ukraine. And the fact that the Minister of Finance of Ukraine spoke in the Parliament of Ukraine that he needs 70 billion to fulfill decisions by judges, but there's decisions of judges or administrative court are aimed at protection of rights of Ukrainian citizens who have, according to the legislation, have right for certain social benefits. Now we are in a situation of war, and to keep this situation with democracy, with rights and freedoms and rule of law is not easy. And the Constitutional Court is the stronghold for judiciary authorities. The stronger it, the more it is independent, the better it stands against any blows. Then the more independent are judges of judiciary system. Thank you for this interview, and glory to Ukraine. Glory to heroes. Thank you very much for answering our questions. We've got a lot of useful information in order to take objective decision by the results of this interview. On this, the interview of advisory group of experts with the candidate on the position of the judge of the Constitutional Court of Smokovych Mykhailo Ivanovich is finished. Please leave this room. Give us an opportunity to consult. Thank you.